I will now call the 10:30 case. It's now 10:45. State of Kansas versus Stephen N. Manczuk, case number 126901. And counsel, would you please enter your appearances?
Good morning, Mr. Chief Justice, and may it please the court. I'm James Latta of the Appellate Defender's Office. I'm representing Stephen Manczuk. I'm ready for argument, and may I please reserve 3 minutes for rebuttal?
3 minutes will be reserved. Thank you, Mr. Latta.
Thank you, Your Honor.
May it please the court, on behalf of the people of the state of Kansas, Assistant Solicitor General Ethan Ziff Sigler, present and ready for argument.
Thank you, counsel. When you're ready, Mr. Latta, you may approach.
May it please the court. Again, I'm James Latta of the Appellate Defender's Office, representing Stephen Manczuk. I wanted to focus my oral argument today on the merits question for the statutes of limitations for the sexual exploitation crime. Is where I wanted to start, unless anybody wanted to talk about jurisdiction. And for that argument, for the statute of limitations, specifically for sexual exploitation of a child, I want to first start by clarifying that the Court of Appeals expressly found this issue preserved for this argument I'm raising right now, and that the state did not petition on that, so that preservation ruling now stands. Now, getting to the merits of that argument, it seems to me that everybody keeps misinterpreting my argument. My argument is based, as it was raised below, based on KSA 215103 subsection D, that says that this code has no application to crimes prior to July 1st, 2011. And because these crimes occurred before then, the statute of limitations that's found in this code does not apply. It's the prior statute of limitations that occurred at the time of the crimes of conviction. So I think the Court of Appeals misinterpreted my argument as saying that the statute of limitations is substantive, not procedural. That's not my argument. My argument is based on subsection D. And then I think there's another misinterpretation is that I'm arguing that the statute of limitations can't be applied retroactively, which is what happened in some of those cases, that are cited, the Nunn case and the Noah case. But this argument was not raised in those cases. This argument, as far as I can tell, is an argument of first impression for this court. And so because both the charging document encompassed time prior to July 1st, 2011, and more importantly, as cited in my brief and petition for review, the evidence points out that these crimes occurred before that date. So because of that, basically because the evidence shows that a crime occurred before July 1st, 2011, we get to the second sentence of subsection 8, which says a crime is committed prior to the effective date of the code if any of the essential elements of the crime as then defined occurred before that date. So now that we're in that area, we then go to the last sentence that says that prosecutions for prior crimes shall be governed, prosecuted, and punished under the laws as existing at the time such crimes were committed. Based on that, we're asking for the 2010 statute of limitations, the one cited in my brief, to apply, which says that these crimes expired 5 years after they were first committed, which the Court of Appeals found would have been in 2016 for the sexual exploitation of a child crime.
Okay, so on that issue, 2151, okay, you have to read everything together. So you've got 215107 is a statute of limitations, explicitly includes older crimes, and then substantive laws can't apply retroactively according to 215103D, right?
I think just this code has the whole entire code, nothing in the code applies. Substantive, procedural, nothing is my argument.
Okay, but would you say that this is, all right, you can continue with your argument. That's fine.
Okay, Your Honor. So then I guess I'll
Sorry,
get,
can I,
Yeah.
before you dial
Yes,
too
sir.
deep into the merits, I guess I did have maybe I need some clarification on preservation. This argument that you're now asserting was first raised in a motion, post-trial motion?
yes, Your Honor.
Okay. And the panel reached the merits, and your argument is that the state didn't cross petition the preservation issue, so we cannot reach it on as the Supreme Court.
Yes, Your Honor, that is exactly right. Even if erroneous, it must stand now.
Okay. If that weren't the case, I'm just curious, do you think a post-trial motion is enough to preserve, to meet the preservation rule for an affirmative defense?
So, dangerous question for me. So under this court's case law, I don't think we've ever expressly said whether or not. My argument would be that, and I think this is what the Court of Appeals kind of is implied in there, is that the post-trial kind of related back to the first motion. So standing very firmly on the grounds that this isn't before this court, I do think a post-trial, based on this court's case law, a post-trial motion would be too late based on what this court said, that it's waived if you don't raise it by trial. I mean, that's what this court has said, so I don't want to seem too crazy.
But I understand your own preservation argument to the preservation question.
Right, yes. Okay.
Okay, so I want to jump off a little more.
Yes.
This case has so many issues,
Right.
but on the preservation issue, do we have the authority to correct the Court of Appeals if they erred in addressing an issue that wasn't preserved? Because what happened, the basis for their decision is that the basis for their decision was it was preserved because there was no waiver at trial. And so they rejected it on the merits. But they failed to acknowledge, as Justice Wall says, that there was that what was being argued wasn't what they didn't waive at trial, but it was a
Right.
brand new argument.
Right.
So because they made a legal mistake, can we address it without a cross petition for review? Or
My response is no, simply because there's no procedural, what comes before, whether or not it's a legal mistake, any kind of mistake, this court doesn't have a procedural avenue to get there because the state didn't cross petition. So that, I mean, I
so
think.
we don't have the power.
Right, yes, it's not before this court. That question, the question of
Is
preservation.
preservation in that sense jurisdictional, or is it like we don't have the power because we don't have jurisdiction over it?
I would say in this case, I'd say it is jurisdiction. I mean, it seems at least quasi jurisdictional, where you have express rules where this court says you have to petition these issues, and that wasn't done.
Right, but our
That-
rules aren't jurisdictional. We create the rules.
I agree. I mean, I don't know what I want to call it, but just by rule, I don't know how this court would reach that when it wasn't cross petition. I mean, that's based on this court's case law. That this court has said many times that specifically to preservation, when the state hasn't cross petition preservation, this court has expressly said that's not.
What if it's a
before.
plain error?
Plain error, I don't know. Doesn't seem like it would apply. It seems like that goes more towards the defendant. It also, plain error wasn't raised. So
That's what I mean, we can address that under plain error if it was plainly, I forgot what the rule says.
sure. My response would be that this isn't that preservation isn't a type of plain error that this court should be getting to. Expressly when the state had the option to put it before this court and they chose not to. And I'm relying on the rules, and as this court has cited them in many cases, that says that, I mean, expressly to preservation, this court has said when the state doesn't cross petition preservation, that stands. And that's a case law I want to stand on for that issue.
If we assume that you're correct, that the statutory argument you're making was preserved, is that enough, or would you have also had to preserve the factual claims you would have needed to make about tolling?
No, my argument is that once the defense counsel below filed the motion, with a different argument that that it had told for sexual exploitation of a child. Once that happens, my response is that the state is then put on their burden that they have to meet these expectations. And it's not this, I kind of analogize this to like an immunity motion, or maybe even a motion to suppress, where once the defendant files this motion and gets it going, then the burden flips onto the state. And the state has to be the one to come forward with these exceptions if they think they apply. Now, I understand the argument wasn't raised till afterwards, but then the state still needed to come forward with these exceptions. I mean, that's what I'm going to stand on for that. The state had the burden.
Why would they have to do that if they win below
But they should have came.
on the statutory argument?
I understand they should have came back at the post-trial motion then and said, let's do it now. Let's put on, if this is the argument now, let's make sure, let's get into these exceptions.
Didn't the defendant lose on different grounds in the district court on the post-trial motion?
Yes, but then I guess I don't understand why the defense didn't raise the exceptions. So I guess I will address one of
The rationale for the district court's ruling on the post-trial motion was that statute didn't control the statute that you are relying on.
Yeah, I mean, my reading of the district court's ruling is they really kind of ignored the argument, and they just said that this court has said that this statute of limitations is procedural, and they didn't really address that 21-5103 subsection D was my understanding of the ruling. But I still, even if that's the ruling, I don't know why the defense would say, I don't know why the defense would put on evidence of exceptions to lose.
Okay, so if you say the district court made a decision on a pretrial motion and then the pretrial motion is dismissed, expired statute of limitations, and at the motion to dismiss hearing, the court held the amended statutes applied retroactively and denied the motion to dismiss. And then after trial, there was a new theory raised, okay? But the judge just seemed to say, oh, I already ruled on that. Right?
I would
So he
agree.
really didn't even acknowledge that there was a different theory. So then it goes up to the Court of Appeals, and the Court of Appeals is like, well, right, but, at trial, it's preserved because he didn't waive it at trial, but that's under the old theory. So, it just seems like the whole thing wasn't preserved.
I understand. I mean, I think my best argument is the Court of Appeals expressly said Manczuk did properly preserve his current argument, and the state did not cross petition. That I think is my best argument.
And I understood, I'm sorry,
No, you go ahead.
but then I understood you to say that the Court of Appeals misunderstood that argument.
Right.
And so I don't think you get in the door under one notion and then say, hey, now I can change my notion. So if the Court of Appeals ruled it was preserved, what was preserved was something that you're now not arguing because you're saying they misunderstood your argument.
Well, I think that
It doesn't make sense to me.
I understand. So I think they did. So right after there's a paragraph where they say it's preserved, and then they cite the entire statute for 21-5103 subsection D, the Court of Appeals, right underneath where they say this current argument is preserved. They cite that entire statute and then they go through it. I mean, I think they misunderstood it when they got to the other case law that the state was citing, but they knew that we're raising it under this statute. They cite the whole statute right under where they say this is preserved.
They also say what your argument is.
I understand you.
Okay.
I mean,
So my follow-up would be, let's assume that you're correct, that the substantive outcome here is that the 2010 statute of limitations applies. Don't we still have work to do is my fundamental question. Because no one anywhere ever evaluated the tolling of the 2010 statute.
sure, then, so
I mean,
think I
I
see what
just
you're
don't
getting
see
at.
how
You're
you
gonna
can, I don't see how you can gain a 100% victory, even if you prevail on your legal argument.
sure, my
Does that
first,
make sense?
yes, it does. And my first response, which I don't think this court likes, is that the burden was on the state to, and then the state has to come forward with everything. Once we say
That's a
statute of
burden that is on the
limitations,
state if you had raised the issue before trial. I don't see how it can be a burden on the state after trial.
my response would be that it related back to it, and the state should have done it in the post-trial motion as well. Now, I understand you don't like that, so in my backup argument would be that we would ask that this court would remand then for the factual findings, please. If there's no other questions, I believe I'll stand on my briefs and petition for the
Any
record.
other questions, colleagues?
Thank you, Your
Mr.
Honor.
Latta.
May it please the court. I guess I will start with preservation issues since that was the hottest topic. The state did not cross appeal. Generally speaking, issues not cross appealed can't be considered. One of the exceptions to that is plain error. And the way plain error would interact in a case like this is if the issues can be reached on the merits without addressing the question below and essentially adopting improper law, those issues aren't preserved. But the plain error doctrine generally holds that this court cannot adopt improper law, and because it was just not procedurally brought up. In this case, that would essentially function to, can this court get to the merits of an issue that is an affirmative defense that was not raised below? And Justice Wald, it looked like.
No, I was getting ready. That's the question I have. I mean, it was raised below, but it was post-trial. And so,
Well, it's a complicated issue, obviously, because it was raised below as to the sexual exploitation and it was abandoned as to the off-grids. And it was not abandoned as to the on-grids, but the issue is that what was not abandoned as to the on-grids was a due process argument, not an argument that the statute hadn't been properly extended because of the saving statute or the recodification statute. And then post-trial, they changed the argument. But the problem with that is that this court has found, and very recently found, that the statute of limitations is an affirmative defense. So if it is not raised prior to the trial, there doesn't seem to be a way to raise it post-trial if those issues have been abandoned. So that would be my argument. In this case, potentially adopting the Court of Appeals position that it was preserved by the post-trial motion would result in plain error because you would have to adopt an incorrect legal standard to come to that conclusion.
and it's quite simply a new statute of limitations theory is really never properly raised through the vehicle of a post-trial motion.
No, it's not. And I actually believe, and I was just rereading the Court of Appeals opinion, I think they actually say that in the opinion as to the off-grids. So there is some internal, but I might have been misreading that. But I believe in this issue, adopting that would result in plain error.
Is part of the reason for that deciding whether or not a statute of limitations bars a claim is a factual determination that really ought to be put in front of a jury?
Yes, and I think that was actually one of my arguments below, was that because there's multiple issues at play, including what Your
In other
Honor.
words, if there's a tolling claim, it depends on facts. Those
Correct.
facts need to be decided by a jury, and it's just too late post-trial.
Yes, Your Honor.
Okay.
And I believe that was actually part of my argument before the Court of Appeals, is that tolling interacts with that on the factual basis. And the statute of limitations involves both claims where you have to address tolling before you even get to the issue of extension. I just briefly want to talk about the merits in case. The question of the saving statute, and I want to be specific as to it, that the crimes in the recodification will only apply prospectively. This court has issued a prior opinion in NOAA in which it has said that that language in particular does not apply to extensions of the statute of limitations, or rather that statute does not bar extensions of the statute of limitations found within the recodification. Importantly here, this court has routinely through its history found that when it issues a judgment to the legislature, that wording has adopted will have a specific effect in law, that wording will continue to have the same effect in law going forward, and that the legislature may rely on that. I know this court has recently begun to claw back some of its interpretations of that, but I believe that in this case, there is a moral claim to be made that when this court has told the legislature, you will have this effect granted by this court, it must continue to have that effect going forward because the legislature relies on the rulings of this court when writing legislation. And I believe that the statute of limitations should be retroactively extended by the language of the recodified statute because it had previously happened in, I believe it was 2007. And this court considered that in NOAA and said, yes, that language is appropriate for extending the statute of limitations. And that going forward, the legislature should be allowed to rely on this body's words when crafting legislation. And that would be my main point on the merits. If there's nothing else, I will stand on the briefs. I will briefly say that this court granted review on cumulative error, but I did not see that there were any trial issues that were addressed. So I just want to briefly state that Boulder-Schmidt was not raised in this case, and the only other issues were legal issues. So I'm not sure if there is a cumulative error argument to be made at this time based on what has been granted on review.
Thank you. Any questions, colleagues? Thank you for your arguments.
Thank you, Your Honor.
Mr. Latta, you reserve 3 minutes.
May it please the court, unless there's any questions, I'd waive rebuttal.
What do you think about the notion that a remand is impossible here because the jury's been dismissed?
Even if that's the case, then I guess we'd have to just go the route of ineffective assistance of counsel. I guess.
Well, that's always a possibility.
But I mean, if I know this court, I don't know of any special rules to recall a jury. So
but that goes directly to the rationale undergirding the preservation rules. In other words, let me put it a different way. Do you agree that the factual resolution of the tolling claims, if they were made, is properly a jury question?
I do not. I think that would be a question for the court, although I have read.
The court has to make fact findings?
Yes, for the statute of limitations, yes.
As opposed to the jury?
Yes, just like the court makes fact findings when it comes to other issues like motions.
It is analogous to speedy trial. I remember speedy trial, counting on my fingers how many days. Is the
Sure.
tolling provisions analogous to that, or where a court does that calculation? Or is it something more than that in terms of a fact determination?
I don't see why it would be any different than seeing why it was told, why the statutory speedy trial was told. It seems
Do
pretty
you have
similar.
any case that says the tolling fact findings is for the court, not for the jury?
No, I don't. I mean, this court in a case called Palmer did say that it was possibly a jury question.
I mean, typically when we have tolling issues or issues of like discoverability, when even in the civil realm, when a plaintiff should have known that their cause of action had accrued, I mean, those are all jury questions, right?
Right, but I don't understand why then the statutory speedy trial facts questions wouldn't also, whether or not that told wouldn't be a jury question.
Okay, so in the statute, when it's talking about the tolling with the two or more of the following factors, the first is whether the victim was a child under 15 years of age. And I looked through the record. I can't say that I read every word, but I only found the year the victims were born. I never found an exact date. So is that in the record? Do you know?
There is an exact date in there.
Okay.
There is, and I think it's in the cross-examination. I don't want to say it now. I don't want to put the
Right.
but there's exact data that is in the trial. In the trial, yes.
Oh, I looked there, but but the other thing is the victim was of such age or intelligence that the victim was unable to determine that the acts constituted a crime. How on earth can we make that determination?
You can't. I understand you can't,
Okay.
so.
Any other questions, Mr. Ladd? Thank you very much.
Thank you.
both for your arguments this morning. Court will be in recess until 9 a.m. tomorrow.